his remorse. Oceans you fill for yourself alone. Florida Samson that now dethroned. So pity your river, not a drop for him. Your high ground's a shadowy west end. Samson, not back with your selfish woes. No room for the tears, only you.
Welcome, everyone. I know that I covered yesterday's hearing last night, but I was told reliably in chat to cover the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome. So here we are, and I have heard that it is has some mic drop moments, so we might be looking at some of those. And I am here for it because the more Sarah intends to use this and her behavior and demeanor of her defense attorney, yes, I'm looking at you, Mr. Owens, yesterday, you two are a match made in Hades. But let's get into this and not waste a whole lot of time. Comes now the state of Florida by and through the undersigned state's attorney or state's assistant attorney and states and alleges as follows. 1. The defendant filed an amended notice of intent to rely on the defense of battered spouse syndrome on September 15th, 2024. 2. The defendant was provided discovery over 4 years ago. 3. By the defendant's own admission, her expert, Dr. Julie Harper, saw her in 2020. 4. The discovery in this case shows that the decedent and the defendant engaged in alcohol-infused spats of violence against each other periodically. No lies detected, and maybe it's Satan or maybe it's Zinfandel. 5. This no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the McNaughton rule. Ouch, mic drop. He's like, none of this is how any of this works. 6. The conclusory statement that, quote, in particular, the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, the distinct behavioral and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from BWS, and the impact of BWS as it relates to the facts of this case. Does not set forth the particular evidence that shows that the defendant suffered from this syndrome. The state's concern that the defendant is alleging does not meet the criteria for battered spouse syndrome is not premature. The discovery does not support a diagnosis of battered spouse syndrome, and the defendant has not alleged new facts to support battered spouse syndrome. 8. Battered spouse syndrome is not actually a defense to a crime. The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable, to show in spite of a reasonable perception of danger from the battered spouse, the battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Quindano versus State, and there's the citation of those cases. So basically what the state is saying here is this is only to be used as, yes, a reasonable person might be tempted to say, why the hell didn't, let's say Sally leave the house when, Jack was, leaving her in the hospital every other weekend. But Sally kept going back. Because, there is unfortunately very complex and very, hard to deal with behavioral, emotional, and many other factors that can make it very hard for a person who is by all accounts, should leave this house and run away screaming, stays with their abuser because of many factors. And they've been able to kind of quantify these factors and put them into battered spouse syndrome to alert the jury that yes, anyone, reasonable might look outside this situation and say Sally was fully capable of leaving the house at any time. You know, Jack didn't lock the doors. Jack didn't, barb wire the house or booby trap it. Why didn't she leave? And then why, when, certain things tip all over and she becomes fearful of her life, did she react in a way that was, could be deemed self defense? It's getting over that hump in the perception of the jury of chick could have left or the man could have left. Why stay with that person? It was meant to be a reason or a way to explain to jurors, once there is proof, once it's backed up by psychologists who do believe that this was going on, give them more understanding of why this woman simply didn't leave or this man simply didn't leave. This is what it was made for, not for Sarah Boone to claim that she self-defensively locked George into a Samsonite. 9, there is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any such new evidence in her notice of intent to rely on battered spouse syndrome evidence. Again, from what I'm reading and from what I took away from the hearing, battered spouse syndrome seems to have solely been used in the state of Florida as kind of an addendum or an explainer when a victim who claims to use this defense wants an explanation as to why, they didn't leave, why the door was open, you didn't leave, why did you have to use the force multiplier? There has been no allegation of, self-defense in this case. Like, I didn't, lock him in a suitcase because I was scared of him, so I got him in there and locked him in there. Again, there has been no evidence that she self-defensively used said suitcase. And even the judge was like, how do you self-defend with a suitcase? Look, the judge was, I'm pretty sure, feeling as though he was about to have a stroke at this point. So he was doing his best to not show on his face how disappointed he was in every single one of us, but mostly the defense for bringing this up. 10, the defendant told law enforcement, when asked about the decedent's other injuries, in all honesty, we haven't gotten into it. Page 3, statement on 2/25/20. Defendant said that she and the decedent were having a good time on Sunday, having wine, painting, doing puzzles, and listening to music. No one laid a hand on nobody. Page 2, statement given on the same day. I have not touched him. We had a good day. It was a good day. We've had good days lately. Page 5, statement on the same day. D, there was no ill will between us last night. Page 8, and these are the statements given the day before, so 2/24/20. Last argument, maybe last week. Page 8, statement from 2/24/20. I was so happy, like it was such a good day. I kid you not. Page 14, statement 2/25/20. Nobody touched nobody. Nobody touched nobody. Page 15, statement 2/25/20. It's the drinking. That's what it is. It's the drinking. I thought it was like, I thought he was okay. Page 34, statement from 2/25/20. Everything was fine and dandy. Page 24 or 42, statement 2/25/20. Question, why didn't you just let him out? Answer, to be honest with you, I don't know. Page 45, statement from 2/25/20. I'll never drink alcohol again. Page 46, statement from 2/25/20. Question, what was your motivation for leaving him in the bag? Answer, I didn't have any motivation. It was me. He and I having a great day, fooling around and being stupid. Apparently me going upstairs and going, I'm blaming it on the wine. Page 49, statement 2/25/20. The next statement, question, you two didn't lay hands on each other? Answer, no. No. Page 53, statement 22520. I don't have any injuries. He and I had not been at it with each other. Page 54, statements from 22520. She didn't do this intentionally. Alcohol is a shitty thing. Page 56, statement from 22520. So it's like, okay, so while we're in a good place right now, I'm going to snap. Is that what it is? While we're at a good place right now, page 57, statement 22520. Sarah, it really does suck when they use your statements against you, doesn't it, sweetie? Maybe you should have asked for a lawyer and shut the hell up. I know you're incapable. I think if you don't speak, you will explode because your internal rage and self loathing would all stop being contained. So I get your point as to why you do talk, but it's a bold strategy, Cotton. See, that's the thing too, but you clearly tell me that I had, or you can clearly tell I had been drinking some. Page 68, statement from 22520. I didn't touch him, nor did he touch me. Page 73, statement from 22520. 11. Defendant's account is not one of self-defense, but rather accident. Wagner versus State. Battered spouse syndrome is not itself a legal defense, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense when a defendant is charged with a crime against her abuser. If the defendant has changed her account, she has not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. 12. Therefore, the state renews its request for the court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. 13. Additionally, the state renews its request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. This is so gangster. They are like, not only do we ask that it's not even brought or, not brought in, but it can't even be mentioned until and unless they bring in the deadly force. And Sarah's gonna be like, I stuffed him real hard into that suitcase. I mean, allegedly. I mean, unintentionally. I mean, damn it. I'm gonna have to admit to something. Ladd versus State, quote, defendant's argument is that the trial court thereby improperly required defendant to testify. We disagree. The trial court did not err in determining that no other testimony provided a predicate for expert testimony. Thus far, the state is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the decedent and the defendant. There is zero evidence that this was a justifiable use of deadly force. The defendant has stated the exact opposite, and she is the only one who can testify that it was a justifiable use of deadly force. So, and then this is the certification that he sent this into Mr. Owens. And Mr. Owens is super duper mad because he's like, he said the state wouldn't object to us using this. No, the state didn't object to you filing a motion, but my guarantee guess is that this is the same reason that Sarah's first attorney dropped this about a week before trial, because it doesn't line up. And I don't know in what world the defense attorney is going to make a suitcase a deadly weapon, but I am here for the shenanigans. And it's really weird. Generally, I am not a super state kind of person, so to root for the state is weird. But at this point, do not let this woman get away with shenanigans. Do not let her lawyer get away with shenanigans. The way that lawyer behaved yesterday in the hearing was honestly one of the most unprofessional things I have seen. His constant whining and trying to relitigate the embiggenment of time with the judge was, I mean, honestly, more pathetic than when my children do it. And I have grace for my children because they're children and they will try to relitigate stuff. But, sir, you are not a child. And the judge has made his motion. Live with it for the last time. And I will say this only one more again. You saw the flying monkeys. You saw the dumpster fire. You saw Sarah and you saw this circus, and you were like, not only do I want a ticket, I would like to be the ringmaster to this S show. So you made your bed, you didn't do your research, you didn't realize how absolutely done with Sarah this judge was, and you thought you could come in and get a continuance. And you should have read the room. And you should have really, really figured out that this was maybe not a case that you should do. But you signed up and now you are whining about everything. And it's really annoying when, again, it's not like you were forced. It's not like Sarah, waited outside the jail and, got you when you were going in for another client. You volunteered. Now, if you volunteered without doing your research, that's a you problem and you have this case to do. But I severely doubt with the questions that the judge was asking and the sort of really constitutional and case related law that he was using to try to get the defense to explain how this is use of deadly force. I will be shocked if they are allowed to use this motion, and I'm guessing we can see a lot more crying from Sarah Boone's side of the courtroom. But those are just my opinions. As I say, I am not a lawyer, but I can read rooms relatively well. And I think the judge is about this close to putting, like, just grounding everyone on the defense side in this case. But I will see you guys later. Have a wonderful evening or Friday. And, a great weekend. Be kind to yourself, be kind to others. And, if you are looking for something a bit lighter, a palate cleanser, if you will, consider stopping on by to this channel on Saturday at 3 p.m. Eastern Time. Veilhammer Media and myself, we do what is called Legal Shenanigans Theater. It's kind of like Mystery Science Theater. It is kind of like hanging out with your friends to make fun of people. And it's kind of like watching interrogations. So it's all that mixed together in hilarity. And we have the big fish, y'all. Daryl Brooks. We have finally broken down, and we are giving this man his moment in infamy and roasting the ever-living Schnell out of him. So if you feel the need to release some aggression by making fun of Daryl Brooks, I think that's not maladaptive. Do not ask your therapist, because I'm sure it is. But, join us, and we will see you there tomorrow. Bye, guys.